Hello, my name is Jonathan Walton. I'm a director at Whitley Stimpson. Quite frequently, we have to call on other professionals for bits of help in the same way that a general practice doctor might, for example. So a client will come to us for all sorts of problems and queries and questions, and very much like going to a GP to come and do like a general surgery, we might have to refer someone to an absolute specialist in a certain area. And one of those types of specialists is someone who's very familiar with insolvency procedures and also business recovery. So I'd like to introduce Peter Windatt. Now, Peter has worked with our firm on a number of cases over a number of years. Peter, would you like to tell people about yourself?
Well, I'm an insolvency practitioner, but apart from that, I'm quite a nice bloke. I've been doing nothing but insolvency and fraud work since 1985. So yes, broadly, I've seen it all before. I predate the current legislation by some years. When I started, we were working with the Bankruptcy Act 1914.
So for the listener, what exactly is insolvency? There are normally two bits to it, aren't there, or two strings to that bow? So explain.
Are we going to talk mostly about companies today? Do you think, Jonathan, or do you want to cover individuals?
Today.
Companies, yes. Okay. Well, for companies, there are two tests of insolvency. One is, are your assets exceeded by your liabilities, including contingent and prospective? And the other and the most real test for insolvency is, can you pay your debts or any of them as and when they fall due? And that's the cash flow test. And these days, it's the cash flow test, and it really always has been. People run out of cash. Cash is king. They die if they run out of cash, and the speed of failure these days is a lot faster than when I first started in insolvency. People are factoring far more. People possibly even don't know that they've had a bad debt until they go to draw down the wages for this week's salaries, and they can't because one of their clients has gone bump without them even knowing it, and the factoring company is on it, and they're aware, and there just isn't enough headroom in the agreement.
Indeed. And so from a cash is king perspective, when do you normally get called in by other professionals for discussions? I mean, is it when businesses are in trouble? Because, ultimately there is a point of time where actually people might need your specialisms to restructure debt or to enter into agreements with creditors or to enter into sort of CVAs or things like that, so that the company has some length of survival. I mean, the primary concern is the survival of the client, isn't it?
It can be. 99 times out of 100 it is. I mean, 50% of the work I do is solvent liquidations, probably by number of cases. So in those cases, their time has come to an end and they're calling it a day. I think the biggest regret of all insolvency practitioners will be that they're not called in soon enough. And so very often we're called in on a Wednesday when the payroll is due to be paid on a Friday. Yeah. And there just isn't very much time to do very much. So if I have a mantra,
the key then is calling somebody in for the right advice at the right time, isn't it?
Yes, absolutely.
And so in terms of an indicator of when that might be, based on your experience, you say that people call you in a bit too late and, when something's due out. When is the right time from your experience of the cases you've been handling?
Well, I can understand people not wanting to cross my threshold or pick up the phone to me. It's an admission perhaps of failure in their view. But of course, nobody reads about all the people we help. They only read about the formal appointments, and they really are just the tip of the iceberg. Most people that contact us don't need our formal help. They just need a bit of a wake-up call and pointing in the right direction. And very often creditors, when they are approached with both the problem and a solution, they want to be helpful. But when they're only discovering that there is a problem because your check isn't in the post or because your direct debit or your standing order isn't being honoured, then they will take their own action, won't they? So being positive, being proactive, going to people not just with a problem but also with a proposed solution, that's got to be the best way to deal with things. It's the mature, the grown-up, the adult way to deal with it. But it's a very difficult thing, isn't it?
It is. But in addition to that, there are some quite nasty little provisions in the Insolvency Act that can come back and hurt directors personally, aren't there? Things like fraudulent trading, negligent trading. In terms of looking at sort of COVID and how things have happened, there was originally something published by the government that came into force, I think, on the 1st of April, which lasted for 3 months. But there's also now a new corporate insolvency and governance bill, which is just literally being rushed through. What sort of things are happening under the COVID kind of, it's not regime, COVID situation that are helping?
The thing that people seem to be focusing on is the suspension of the wrongful trading provisions. And just so that people are aware, wrongful trading is when you continue to trade a business on after the time when you knew, or you ought to have known, that there was no reasonable prospect of avoiding insolvent liquidation. Now, suspending those provisions, I think, has been done in part to stop people from being bullied into the arms of people like me. You know, it's quite easy for a less honourable insolvency practitioner to scare the Jesus out of a director and say, oh, you know, naughty, naughty, you'll get caughty sort of thing. And if you're caught, you could be held liable for all of these liabilities, which of course is true. But the headline seems to have been wrongful trading has been suspended. A lot of the people I'm talking to at the moment are telling me that COVID is the source of all of their problems. But when I look at their accounts, oh, look, they were insolvent 3 years ago to the tune of 52,000, insolvent 2 years ago to 64,000, and most recently insolvent to the tune of about 100,000. So frankly, between you and me, and I did actually say this to them, look, mate, you've been in a hole and you kept digging.
Yeah.
COVID might be the straw that has broken the camel's back, but actually they've probably been trading insolvently for about 3 years. And the least of their problems is the 3 months currently when they probably haven't actually incurred any liabilities. But it's a good headline. I think it helps people address the immediate concern that if we're carrying a company on now, are we at risk? And the answer is you're at less of a risk. The wrongful trading risk may be gone, but trust me, there are plenty of other risks within the Companies Act and within the Insolvency Act that they could get caught by. Trading, selling things at an undervalue, preferring one creditor to others, that sort of thing. I mean, the thing that really frightens a lot of directors at the moment is, you know, they've, for very tax efficient reasons, been paying themselves through dividends and a very low salary.
Yeah.
Well, dividends should only be paid from distributable profits. And are there any?
Yeah.
Is the paperwork right? That sort of thing. So,
and that's you know, if you get that wrong, you're in a fair amount of trouble, aren't you? I mean, basically, you know, you're supposed to have a set of accounts under the Companies Act that reflect the assets and the liabilities. And, you know, a lot of people do the processing of their, you know, raw data, but they don't necessarily think about the provision of the tax liability, because obviously if you're taking a dividend, you're using profits. So you'll end up with a corporate tax liability because obviously the dividends aren't deductible. And so some people don't necessarily have a handle on really what their true profitability is, do they? And they're used to having a sort of a low earnings limit salary of, you know, sort of £9,000 and then taking the rest out when spousal dividends as well. And those can be repaid, can't they?
Well, we can challenge illegal dividends, as they're referred to. We can challenge repayment of directors' loan accounts because often that's deemed to be a preference. And of course, wrongful trading, what happens in those situations, so looking at the company I was just referring to, which has traded wrongfully arguably for 3 years, the likelihood is that all of the creditors in that case would be able to look through a liquidator or an administrator to the director to make good the shortfall. Yeah. Because it must have been clear, or it should have been clear, that this company was unlikely to avoid insolvent liquidation, but they carried on, quote unquote, willy-nilly, and it's COVID-19 that has broken the camel's back.
Of course. One of the other things in the new Corporate Insolvency and Governance Bill, which has been around for a long time, which I'm not sure that many accountancy practitioners know too much about, but it's the ability to do a moratorium, and so just explain what that is.
Well, we don't actually know what the proposed new moratorium is going to be exactly, but there have been things called moratorium CVAs around for a long while, and the whole thrust of the administration legislation is to provide a moratorium. And a moratorium basically prevents, without the leave of the court, anyone from commencing or continuing any action. Now, you can go to the court and you can get leave to continue, and in a lot of cases, where people want their assets back from an administrator. If the administrator doesn't need those assets, you don't need to go to court. They'll just agree that you can have those particular things back.
So is that a formal court process to obtain a moratorium?
The new situation will be the directors applying, I believe, and then there will be a freezing for a period of weeks, which can be extended, and so on and so forth. And what is good about it all is whatever it ends up being, and I think what it ends up being is fairly well known now, but whatever that is in the final bill, it's a period of grace to get your house in order and sort things out. Now, I'm sufficiently old that I remember a thing called the London approach. And the London approach was where creditors would literally get around the table and agree how things would be carved up and moved forwards so that everybody saved face and everybody avoided mutually assured destruction. And at least they got something out of the situation. And it's about understanding what is possible with what is available. If everybody tries to race to the front of the queue, then there's just going to be a melee and everybody loses, hopefully by having an orderly look at the situation. Now, the moratorium under the new legislation, as I understand it, it has to be capable of surviving and it has to have a good success.
There was talk of it being 20 days, but you say that could be extended.
Yes, and yes, you can extend just as you can for an administration, which typically is for a year, but that can be extended. You do need creditor approval under the current draft, etc., etc. But I've just written a briefing or a letter to accountants about this subject, and I'm basically saying, don't worry too much about it. Nobody ever phones an insolvency practitioner and says, this is exactly what I want. What they say is, we've got a problem.
How do we...
What's the best solution? And it's just like, you don't go to a shop to buy a drill. You go because you need a hole. You come to an insolvency practitioner because you want to know what the least bad way forward is. If there isn't a good way forwards, then what's the least bad way?
Sure. So as well as the temporary... There's another one, isn't there? The winding up petitions. There's a temporary sale of winding up petitions. So that's the same as the wrongful trading one. I mean, presumably it's just, well, not the same in premise as that, but it's the same approach, is it? From the government, it's just to again buy more time for the creditors. I mean,
bear in mind also that a petition is a court process, and there has to be a hearing. And with COVID having hearings, that's all changed. All of that said, there are now being hearings by Skype and by the professional versions of Zoom and similarly, and the courts are loving it. It's working very well. The lawyers and barristers that normally would have to all turn up for a 10 o'clock hearing because they're all scheduled at the same time are able to wait until they're called into a meeting, and they can do that from their home or from their bed if necessary. It's the normal we return to will be very different from the one we left.
Okay. And one of the other things in this new bill is the prevention of suppliers from terminating contracts or raising prices. So
this isn't the sort of supplier I think that by and large small firms of accountants would have as clients. This is large companies that could use their muscle to prevent people from carrying on trading by just saying no.
Yeah, so I mean, just say, for example, you had a building contractor. I mean, fortunately, some of the building contractors we're out for are doing remarkably well because they're doing schools and hospitals. But just say, for example, you had a building contractor and one of its suppliers was somebody absolutely huge. Would it protect them in any way, or who's it really aimed for?
Yeah, it's the big suppliers, it's the utilities, it's the people with not monopolistic necessarily, but certainly significant ability to constrain trade by simply saying no to people. So it's large companies. I think they have to have the criteria are set up, but certainly more than 50, probably even more than that, employees and very significant turnover and such like. If you're a small company supplying, you're not going to be locked into a uncommercial deal.
So going back to COVID, so I mean, some businesses have obviously suffered a lack of turnover. There's still a little bit of uncertainty. depending on what industry you're in. I still get calls from clients saying, back to work, sales are picking up, but they're nowhere near there. We can obviously do the planning, the cash flow planning, et cetera, et cetera. How have you found COVID-19 period with the people you've been speaking to? And what have been their major problems?
We had a real rush of inquiries immediately on lockdown, as you would perhaps expect. That really tailed off significantly. The furloughing has helped enormously, I think. We have a number of insolvent cases which I think are being delayed. You might say cynically, they would say justifiably, because they're acting in the best interest of, in particular, the employees, because the employees are better off not being made redundant. Yeah. They're better off having 80% of their salary through the furlough scheme and being made redundant later when perhaps they have a prospect of getting a job.
Of course, because, yeah, of course. And so the government have done some, other than furlough, there's been quite a few government initiatives. I was going to just touch on two, actually. The first one was the VAT holiday. And of course, that was a one-off, wasn't it? So the VAT liabilities that are now due, there's no holiday for those, is there?
Yeah, and it's only a payment holiday. It's not.
Yes, it's a deferral, isn't it? But there is, I believe, there's no deferral for liabilities due after July. Is that true?
That's my understanding too. But I would defer to you on anything to do with
that's what I've read. Yeah. So
I can't even spell VAT, Jonathan.
No. Well, okay. No, my understanding is that even though businesses were allowed a deferral holiday, as you say, it's not a permanent holiday, but a deferral holiday for the last quarter, for the current quarter now, where impact of turnover has. Then some businesses have not had huge turnover. But if they're on cash accounting and things like that, they've still probably been getting cash through the door. I guess, to pay their VAT. But of course, some businesses use that cash for their directors' salary.
That actually brings on to another development that was expected in April, but has now been pushed back to December, which is the re-emergence of the Crown as a preferential creditor.
Yes.
Because an awful lot of people still think that, as in pre-2003, the taxman cometh and is first in the queue. But for a long time now, it's been employees principally that have been the preferential creditors. But from December, all of the sort of money you've just referred to, i.e. you pay your £1 and your 20p VAT, that 20p goes in a shoebox until the Batman comes calling for it. That element and others will be preferential again, most likely from December of this year.
That would also presumably apply to PAYE, NI and corporate tax.
So the deductions that are ostensibly made from payroll and should go into another shoebox marked PAYE or NIC. And
again, preferential.
Yeah.
And that's a change, because that's not been the case before, has it?
Well, it was, what was preferential up until the Enterprise Act was VAT for the 6 months next before the relevant date. You love the terminology they used.
Yeah, I remember the VAT had slightly more power than the PAYE.
Well, it wasn't so much that they had more power, it's just that because they were only preferential for 6 months, they fell off the cliff before the revenue did, who were 12 months.
Yeah.
So they were perceived as more aggressive, but it was largely because, I'm not defending the VAT man because my dad was a VAT man.
Okay.
But that is the case. They were preferential only for 6 months, whereas the revenue were preferential for 12 months. But that's
they certainly they certainly had a reputation of being a little bit more feisty and aggressive in the older days, when the departments were very clearly split. The second COVID thing I just wanted to ask you, specific to the things like the loans and the bounce back loans, etc., because I've had some sort of Socratic debates with clients about these loans, especially the bounce back loan. And one of my clients, who I'm not going to name here, but hopefully he'll watch, he was telling me that one of his friends who his accountants just said, well, look, just take the money and then draw it all out, because you're not personally liable for it. That seems like great advice to me. So how do you how do you feel about that advice, Peter?
I think the difficulty in all of these situations, and I'm not trying to justify or condone anything that amounts to fraud and wrongdoing and all that sort of thing, but the question I always have to ask myself, and I'm going to be asked this afternoon likely on another Zoom meeting, is, are these people fit to sue?
Yeah.
it's all well and good me having a right to pursue them, but are they worth powder and shot? And that's the difficult question that I have to answer an awful lot of times. If people have got the money and they've spent it, then chances are, and I'm not picking on people that live in rented accommodation or anything like that, but if they've got nothing, why would I sue them? I don't want Pyrrhic victories, thank you very much. So yes, the cynics out there are certainly going to suggest that they should take it and ask forgiveness rather than ask permission beforehand, if that makes sense.
And in reality, it's a loan, really, isn't it, to boost the working capital or for planned investment? I mean, that's the purpose of the loan as well, really, when it comes down to it. It's for the continuity.
There are going to be people that abuse the system, whatever the system is. There are always going to be people out there abusing it. For the majority of people, it's a fantastic opportunity. It's a lifeline.
Indeed.
And the whole mode of travel for the legislation, if you ignore the preferential status being restored in part for the Crown, the whole emphasis is towards survival, business recovery. The first part of our name, it's the trying to get people to talk to people sooner. It's trying to, if you like arbitration and that sort of thing, it's trying to get people
and that's where you come in, where we, as a practicing firm of chartered accountants, we can deal with the cash flow side of things and look at the business planning and the strategy. But there comes a point in time where you're going to get a call from us and say, look, we've got a client who's got an issue. And so what's your initial approach?
Where possible, avoid me like the plague, because I don't actually add value to the situation. I'm just an extra cost. And I've had the situation with a charity in the last couple of weeks, which is a national charity, a small part of it, of going to all of the creditors and saying, this is the situation. You can have 70p in the pound next week in full and final settlement, or you can do it through me and you'll get 55p in the pound in about 2 years. Yeah. And you've got to hope that they're going to vote for the first option.
But you're kind of independent, aren't you? So you're opening up the communication with the creditors, and there's that level of trust between you and the company and the creditor, isn't there? So
but for me, well, the creditor doesn't trust me in the first instance, because I've usually been approached by the directors and they see me as being in league with the directors, which of course I can't be. Because, you've got to remain independent. But no, the way that I try to look at things is, look, this is what the balance sheet says, and that's all lovely, and it's on a going concern basis and beautiful. But a very solvent balance sheet can become very insolvent if you say it isn't on a going concern basis, and suddenly you're adding 200 employees, all of whom have got 12 years service.
Yeah.
Because that liability for their redundancy, for their paying you of notice, is massive.
Yeah, and it's not recognised, of course.
No, it isn't recognised on a going concern balance sheet, nor is future rent, future lease commitments, breach of contract things. So when a company goes bump, everybody's expecting to buy their stock at a bargain basement amount, and all of these liabilities that hitherto have been hidden suddenly materialise. Yeah. So what I tend to do is take the balance sheet. That's fine. It's accurate. It's all of the rest. Right, now, what's it actually worth, and what are all these contingent and prospective liabilities that are going to come out of the woodwork? And if the stock that has been valued on, quite rightly, lower cost and net realisable value, what's it actually worth? If I take this to the auction rooms down the road, what are we going to get for it after the costs of doing that? And very often, the stock isn't worth the cost of collection, removal and sale. In some cases, it's actually onerous. I remember having 3 gas cylinders, which, because of the change in the CFC legislation, the aerosols and stuff, it was illegal to have in Europe.
Oh gosh. Well, the same is true of plant and machinery, isn't it? Because some of it's, it's got a balance sheet cost and a net book value, but some of it's so heavy to move, and
or it's got asbestos, or it's got
So, but there are other options, aren't there? So if I'm struggling with cash flow, and I can't meet my creditors day by day, and I can have you in to sort of try to negotiate with them, or I can negotiate with them. But when things become a little bit more heavy, if you like, there are options available to me. There are things like a CVA and administration. Do you want to just very briefly just explain what those are for companies?
Okay, well, if we just mention all of the different procedures sort of in order of rescue. Top of the list would be the company voluntary arrangement, the CVA, where you don't necessarily need a moratorium, and it's basically a deal that the company can reach through its directors that both the company and the creditors will accept. 75% by value of the creditors that can be bothered to vote in favour of it, and there's a safeguard against the directors loading all of their friends and family as creditors, because if more than 50% of the unassociated companies voting object, it isn't deemed to have been approved. CVAs, very common in the high street. Landlords are very up in arms about CVAs because they perceive that an awful lot of them have been used as a way of just cramming down on rents.
Yeah. And they can be over a period of time, can't they, where a creditor will get XP in the pound, which they have to agree to. But it can give the company, it kind of freezes the debt at a certain point, doesn't it, for that then to be paid as subsequent. But the company can continue to trade throughout.
A CVA can be anything that is acceptable to both the company and the director. There are very few, I think there's 7 sections in the legislation. There's no prescribed format. You might have what I would call a lump sum CVA, where an angel investor is coming in, putting 100,000 on the table, creditors get 80p in the pound, but everyone keeps their, whatever it is. Or there might be a ongoing trading CVA, where perhaps it carries on for 3 or 5 years, and typically that would be the sort of a range. And out of surplus funds generated, monies are paid back to the creditors over time. That sort of CVA is much more likely to fail than a lump sum CVA. People underestimate the dislocation of being in business and trading through a CVA. If you're making or if you're selling stuff that is homogeneous products, then fine, people will buy a pair of a particular brand of Nike or Reebok or whatever trainers from any number of retail outlets, and they'll have confidence. But if you're selling double glazing, who would you buy from? The company in an insolvency process or the company that isn't?
Well, quite, yeah, well, quite.
So
and the next one in the pecking order after
administrations. For an administration, you do need the court involvement an awful lot more. There is a moratorium. You do get some protection. The downsides, I suppose, are that you need the approval of any qualifying floating charge holders. So whereas historically, you and I will remember things called receiverships, where banks typically appointed people like me to realise the assets for their benefit. Those are now fallen by the wayside. I can't remember how many there were last year, but it wasn't very many compared with administrations.
But again, an administration allows the administrator to, the company can still run through that period whilst it can make a decision about what it can do. So it can go into administration before it goes into receivership, or it can go into administration before it goes into CVA.
Absolutely. So you've got the moratorium, and the outcomes usually are into a CVA, into another insolvency process, or into dissolution. There is a provision there that it's an administration just for the purpose of a blip to get that moratorium and to hand it back to the directors, but that is a fairly rare beast.
Okay. And what else have we got in our armour?
Well, I mentioned receivership. There are some old charges that predate the Enterprise Act, under which people like me are appointed as administrative receiver. I'm not sure that we have any standard packs for those these days, because they were few and far between for a firm of our size prior to the Enterprise Act, but they too can be used as a way of rescuing the business.
Okay.
And then below the line, you've got the liquidations. You've got creditors' voluntary liquidation, which is by far and away the most common. And that's where the directors start the process, and usually their choice of liquidator will remain in office unless the creditors particularly object. And then you've got compulsory liquidation, and any form of liquidation is about winding up the affairs of the company prior to it being struck off at Companies House. So it's getting in the assets, realising them, paying out creditors in their order of priority, preferential creditors first, and so on. I suppose I should mention that the costs tend to top slice all of those, and I would imagine that most people watching will have experienced a nil return from most liquidations, because
exactly, yeah. But I mean, that's the end result, isn't it? The point being throughout the theme of this discussion is to plan, and as you said, if you sort of fail to plan, you've got to be aware of what your position is, what your liabilities are, and really to call on that expert advice early on. If you feel
Yes.
that there are any problems, call upon it early on, because there are so many things that you can do whilst it's all alive and kicking. And this, again, supported by some of the COVID-19 and the more recent corporate insolvency governance bill, which is coming into play. There's a long way to go before a company has to die, isn't there?
Yes, and the direction of travel is about helping those that are viable and should be continued to continue. But it's not about propping up, dead donkeys.
Of course. But there are people that are probably thinking, well, my sales are down, my expenses are similar, my wages are similar. There's this talk of what's going to happen with furlough going forward. I know it's been relaxed. It's actually quite decent as it's turned out with the period of you can place people on furlough, but there is still uncertainty. So I think the message is just get in touch, isn't it?
Yes, if you're trading your business through a limited company, fantastic. That's the first thing I would say is, why would you not trade through a limited company? It does afford some protection. Many of the people I talk to, and the one I'll be talking to after lunch, has guaranteed everything.
Yeah.
So kind of what was the point?
Yeah.
There you go. It is,
and that was one of the nice things about some of the loans as well, wasn't it? The loans that have come out, they are, for the smaller businesses.
Yeah.
And there are no personal guarantees around those.
No. Yeah, I think you've still got to be careful of things like theft act offences, obtaining pecuniary advantage by deception.
Yes, of course.
It's not the Wild West. But subject to that caveat.
Taken out for the right purpose. That's
absolutely. But Jonathan, there are always companies that will fail. My favourite quote in Insolvency: "Capitalism without bankruptcy is like Christianity without hell." Where there's competition, there's always failure.
Of course.
There will always be people that win and survive and some that don't. Which was the better VHS or Betamax? Sometimes the best don't win the race.
Yeah.
But perhaps they had better capital, perhaps they had better management, perhaps they had a better accountant.
Yeah. Well, we probably need to wrap up there because we're just up to half an hour. I think the message for anyone is never be afraid to speak to your professional advisor. Please don't be afraid to speak to your accountants. Your accountants can recognize situations and put you in touch with business recovery experts like Peter. And please do contact us if you have any fears at all, or contact Peter if you have any fears at all, because we're all here to try and help people get to the end. And a lot of people put their heart and souls into their business and have sleepless nights about what's going on. We're always here to help, and I think that's the most important message.
I can only echo every word. Yes, it's better to talk to us before you need to.
Exactly. Thank you, Peter, very, very much.
You're very welcome. Thank you. Good day.
Thank you.